Get out of here by 1 or 2.
All right, so it's a little bit after 10. I'm going to call the Judiciary Committee to order. And first thing, Chair recognizes Representative Andrus to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Just take one that's not controversial.
Yeah. So 27. It's, 27, right?
Yeah. Start off with 27.
All right. So we're
Okay, you're about to miss a motion, buddy. You're about to make a motion.
yeah. That's fine.
Not you, I meant him. Just like went off.
Is that the one that I printed out?
Thank you. 1260. Okay. 260. Hang on. 1260. 1260. Okay. All right. So
Make sure she can get through, yeah. Louise Martin has to get through behind you? It's right here.
Okay, yeah, I'll let her through.
Yeah.
We can get rid of that chair.
Yeah, we got too many chairs.
Over here. We're in the small room, so they changed this around.
You're down right here.
Why don't you just sit right here, man?
no. You can, Marge. You can sit wherever is the most convenient. I mean, that's absolutely.
I want to sit next to Margie, that's why.
Absolutely. Okay.
Louise, if you want to move down one, so you have. Yeah.
I'm fine.
Perfect. There we go. Now you got your own
All right.
copy of this.
So just a couple of sort of housekeeping things at the beginning. So we have 26 bills, because we're going to put 2 off, but we have 26 bills to get through today, and it's imperative that we get through them. My sense from talking to the ranking member is that on a fair number of them, there's really not going to be a sort of partisan divide. We kind of all are on the same page. So what I would suggest, and it's only a suggestion, everybody, we don't inhibit free speech rights here at all. But my suggestion would be, if there is no real debate, that we just make the motion and vote. That will make things go along a lot quicker. The other thing that I would say is I have to leave at 1 o'clock to introduce another bill. Representative Vice Chair Mannion will take over. There are several things. I mean, one bill I'm recused on that I'm sure makes sense for you to take up then. And there are several others that I've talked to the Vice Chair about that, again, don't appear controversial. that you can take up during that time. I'm going to tell the people over in education funding that I've got to get back, and I'm willing to take a couple of questions, but not end up in a debate about this education funding bill. So I shouldn't be too long. The last thing I would say is that my plan is not to break for lunch, to just in the hopes that we get everybody out as quick.
That's going to be problematic on our side. We're having a caucus on a specific bill. Half an
What?
hour.
Well, let's.
So did we.
Well, why don't we do this? Let's maybe what we'll do is if you have a specific bill you want to caucus on, we'll put that at the end, and then we'll take a break so you can caucus, but at least we'll get the other ones done.
It's on HR 300.
Okay. Well, then that's.
20 minutes.
I'm not going to make a decision on that, Janice. You decide that.
Let's just start moving.
Yeah,
forward.
yeah,
right.
We'll see how we get there.
See what we
See what the
get.
time looks like,
Alright.
because
Just-
All right.
I think we can move quickly, that we can make time.
I don't think anything's gonna change between
Alright.
now and then anyway.
So first, I'm going to open the executive session on CACR 27, and the chair recognizes Representative Alexander.
Thank you, Mr. Chair. I move ITL.
Is there a second?
I second the motion.
All right. So it's been moved by Representative Alexander, seconded by Representative Andrus to ITL CACR 27. Does anybody wish to be heard on that? Seeing none, I'd ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully. Oh, he's not here. Sorry. Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
Yes.
Chairman Lynn.
Yes.
17 yeas, 0 nays.
Oh, all right. All right. Representative Alexander, can I ask you to write the, because Scully's not here. All right.
I'm
All right.
happy to write the report.
All right. And anybody have any objection to that being on consent?
I don't, it's CACR.
It's an ITL motion.
It's an ITL motion, yeah. All right, consent, okay. All right, next, I'm gonna take up, hang on, I have all my notes here. HB 1064, and the chair recognizes Representative Kutab for a motion.
I move ought to pass.
Is there a second? Representative Manning?
Yes.
All right.
Second.
So it's moved by Representative Kutab, seconded by Representative Mannion, of ought to pass on HB 1064. Anybody who wish to be heard before we call the roll? Seeing none, I'd ask the clerk to call the roll, please.
Vice Chair Mannion.
Yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
Yes.
Chairman Lynn.
Yes.
17 yeas, 0 nays.
0. Representative Kutab, will you write the report?
I will. Can we do that consent?
Yeah, and anybody have any objection to consent? All right, that will go on consent. All right, hang on. Next. All right, next, I'm going to turn to 1702, and the chair recognizes Representative Manos for a motion.
Thank you, Mr. Chair. I move ITL.
All right, is there a second?
I'll s-
Oh,
Second by Representative Bergeron, okay. Bergeron, all right.
What?
All right. So it's moved by Representative Manos, seconded by Representative Bergeron for ITL. Does anybody want to have any discussion on 1702? Seeing none, I'd ask the clerk to call the roll.
Vice Chair Mannion.
yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully. Scully's not here. Rep. Ball. Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
Yes.
Chairman Lynn.
Yes.
17-0.
17-0 ITL. Anybody have any objection to it being on consent? Seeing none, it'll be on consent. And Representative Manos, can I ask you to write the report, please?
Could I ask a question?
Of course.
Do we, assume that it will stay on consent?
Good question.
The reason for my question is, if the answer is no,
Right.
then we might want to not put it on consent so that it can
Welcome.
be taken up in the normal.
Your wife
course of
okay?
business.
I think
Oh, it's
it'll
not
stay
here.
on.
He's gone.
Yeah, okay.
I think there's a reasonable chance it will stay on. And you know what? Can I just say to everybody on reports, I know there's going to be a lot to be written. So what I'm going to ask is that you please get me the reports by, let's say, 5 p.m. on Sunday. That should give everybody enough time to do it. All right. So 1702. All right, next I'm going to take up 1769, and the chair recognizes Representative Manos for a motion.
Thank you, Mr. Chair. I move ITL.
Second.
Is there a second? All right. Moved by Representative Manos, seconded by Representative Mannion. Anybody wish to be heard on 1769? Seeing none, I'd ask the clerk to call the roll, please. Motion is ITL.
Vice Chair Mannion.
Yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Ball. Oh, Scully is here now. Sorry. Rep. Scully.
Oh, Scully, hi. Welcome.
Good morning, all. Apologies, I had a medical procedure. I'm here now. Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron. Chairman Lynn.
Yes.
18-0.
18-0. Consent? Anybody have any objection? All right, this will go on consent. And Representative Manos, you're up again for the report. Okay, thank you. All right. I'm going to go turn to 1801, and the chair recognizes Representative Mannion for a motion.
Thank you, Mr. Chair. I move ITL on HB 1801.
Is there a second?
I'll second that.
All right. Moved by Representative Mannion, seconded by Representative Tripp. The motion is ITL. Anybody wish to be heard? All right. Then I'd ask the clerk please to call the roll on 1801.
Vice Chair Mannion.
Yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
Yes.
Chairman Lynn.
Yes.
18-0.
So, all right, 18-0. Anybody have any objection to 1801 going on consent? All right, we'll be on consent. And Representative Mannion, could I ask you to write the report?
Yes.
All right, great. Okay. Next, I'm going to turn to HR 28, and I will recognize myself for a motion. I move ITL. Is there a second?
I'll second it.
All right, it's moved by Representative Lynn, seconded by Representative Tripp to ITL HR 28. Is there any discussion? Seeing none, I'd ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Alexander,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. Lane,
Yes.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lynn,
Yes.
18-0.
All right, again, any objection to consent? Seeing none, I will write the report. All right. Next, I'm going to turn to HR 29. And again, I will recognize myself, and I move ITL. And is there a second?
I second the motion.
All right, moved by Representative Lynn, seconded by Representative Andrus. Anyone wish to be heard on HR 29? Seeing none, I'd ask the clerk to call the roll, please. Yeah, no, I'm sorry. Don't. I know you've got all the paperwork to do. So just tell me to slow down. I'm happy to do that.
All right, that was ITL, right?
ITL on 29, yes. HR 29.
Okay, and you made the motion.
I made the motion, and Andrus seconded. Yes.
Does anybody,
No. Take your time. Don't hesitate to say slow down if I'm.
does anybody remember Lucille Ball's comedy routine?
With the
With the
candies?
conveyor?
Oh, yes. I think you and I, Paul, are
No,
probably
I've
the
seen it
only
too. I've
two
seen
that are
it.
old
I've
enough.
seen it. It's a famous one.
Yes, Representative Katab will get the Lucille Ball award.
Right.
All right, so, for HR 29 on ITL, Vice Chair Mannion,
Yes.
Rep. Alexander,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. Lane,
Yes.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron, Chairman Lynn,
Yes.
18-0.
18-0. Again, any objection to consent? Seeing none, and again, I will write the report. I know. All right. Next, I'm going to take up 12. Yeah, 1233. And the chair recognizes Representative Katab for a motion.
I move OTP.
All right, is there a second?
I'll second.
All right, moved by Representative Katab, seconded by Representative Alexander. Anybody wish to be heard on 1233? Seeing none, I'd ask the clerk to call the roll when you're ready.
Vice Chair Mannion,
Yes.
Rep. Alexander,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith, Rep. Horrigan,
No.
Rep. Lane,
Yes.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lynn,
Yes.
17-1.
17-1. Any objection to consent? All right, 71 will go on consent. And Representative Katab, will you write the report?
I'd be happy to. No, he's
Well,
on consent.
Yeah, right, okay. All right. Okay, I'm going to now turn to 1260, and the chair recognizes Representative Alexander. I understand there may be an amendment. Is that correct?
Thank you, Mr. Chair. I move ought to pass. Well, ought to pass, I'm going to move an amendment. So,
Okay, so
I
we
just
should-
need
yeah.
a second to the ought to pass first.
Okay, so we do. Yeah, so we ought to do the amendment first. So what's the
I
amendment?
second.
All right, so the ought to pass has been seconded. So now I'm going to move the amendment
Okay.
0693H.
All right. So and, 06. I'm sorry. 0693.
Yes.
93H. All right. So it's move Alexander. Caitlin, you seconded that the amendment.
I did, yeah.
Second, Katab. Okay. All right. Could I just ask?
Can we pause? Yeah. Can I ask something?
Yeah, no, that's what I was going to ask Representative Alexander if he wanted to speak to his.
No, I just want to ask a question.
Sure,
Because
go ahead.
this amendment isn't before us, but I see that Rep. Horgan had another amendment, and I think I wanted to ask if the amendment is exactly the same. That's all.
Right.
Davis, can you tell IT?
Can you just talk into Kevin's microphone because I can't hear you?
It appears to be exactly identical to the one that I had drawn up. So, like, great minds thought alike, and the people at OLS were very patient with us.
Okay.
So they interpreted we gave them apparently the same instructions, and they produced the two identical amendments. So
Okay.
Representative,
Chair,
I'll go with
Yes.
Can we inquire of Representative Horgan whether that means he's not going to introduce his?
So hang on. So I would take it since they're exactly the same that there's no need for you to introduce yours. Is that
yes,
correct?
as far as I can tell. So,
All right.
yeah.
All right, Representative Manos, you have a question.
Yes, I have a question. In speaking to Representative Horgan about this amendment, he indicated it was more sections than just the section of the law that,
The mic's on. You can do it.
Excuse me. I won't repeat, but my question is whether Representative Horgan's amendment is broader in what the sections of the law that it applies to than Representative Alexander's amendment.
It looks like it applies to all the same sections of the law. It's somewhat broader than what I thought it was going to be after, because it started out with the original bill needed to be made gender neutral, and then apparently both Representative Alexander and I noticed separately that there was many other references in related RSAs. So OLS very diligently made two identical amendments except for the number and the names on the masthead. So that's
Just to clarify, and this is really a question to both Representative Horgan and Representative Alexander. Is the committee correctly understanding that both amendments are the same? There is no substantive difference between either amendment. Is that correct?
that's my understanding. Yeah.
All right. All right. Any other questions? Representative Manos.
Thank you, Mr. Chair. When I look at Representative Horgan's amendment, I see, for example, on page 6, a reference to section 5C:57, and I just looked quickly, but I don't think I see that in Representative Alexander's amendment.
Can you say the number one more time?
Representative, it's on the previous page. The reason why they aren't identically by lines is because you have more co-sponsors, so it shifted down a little bit.
Okay,
It's literally the same amendment.
okay. Thank you for the
Representative
clarification.
Scully, did you have a question?
Well, I just had a question. I didn't see Representative Alexander's amendment in my pile of amendments. I guess if they're identical, I can just work off of Representative Horgan's as you discussed.
Yeah, I distributed copies earlier, but Davis Scott.
All right. So, I guess we're going to work off of Representative Alexander's amendment, which is 0693H. And with regard to the amendment, does anybody have an objection to just a show of hands? Seeing none. All right. All those in favor of adopting Representative Alexander's amendment 0693H, please raise your hand. All right. Anyone opposed, please raise your hand. Representative McFarland, opposed? All right. So the vote is 17-1 on the amendment. 1 on the amendment. Okay. All right, so we're now ready to turn to the main motion. Again, I recognize Representative Alexander for a motion of OTPA.
Yeah, I move OTPA.
All right, is there a second?
I second.
All right, if I could just speak
Yeah.
briefly to that.
Certainly.
I am not too jazzed about the filing fee for a delayed certificate of marriage, so I hope that our friends on the other side of the wall take that out, and I will be asking that they do it, but I'll vote for it for now.
All right. Anyone else? Yes, Representative Tur.
I also wanted to echo the same thought that Rep. Alexander just brought up. It seems as though this fee would be levied upon not the responsible party for that delay. So I think that's worth noting for any future changes.
Sure. All right. All right. Anyone else wish to be heard? All right. So the motion on the main motion then is OTPA, moved by Alexander and seconded by Representative Kutab.
Vice Chair Mannion,
Yes.
Rep. Alexander,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
No.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith, Rep. Horgan,
Yes.
Rep. Lane,
Yes.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lynn,
Yes.
17-1.
All right. 17-1. All right. Can this go on consent?
Question. Are we, I know we can have 3 votes against and have it still go on consent. Can it go on consent with a minority opinion?
No. If you want to write a minority, that's fine. It'll be on the regular calendar.
No, I'll leave it on consent.
All right. Consent. Oh, yes. I'm sorry. Yeah.
Sorry, and I'm a sub, but in election law, we just went through a bill where these marriage certificates would be provided by the Secretary of State and the registry from archives for free.
Okay.
So I'm just bringing that to
Yeah,
everybody's
so that-
attention,
no,
so
that's
when it goes over to
To
the Senate.
we can say,
Exactly.
yeah, no, that makes perfect sense. All right, consent. All right. And Representative Alexander, can I ask you to write the report?
Absolutely.
Thank you. All right. Next, 12, I'm going to take up 1276 relative to liability for the death of a companion animal, and the chair recognizes Representative Perez for a motion.
I move to ITL.
Is there a second? Representative Scully?
Thank you, Mr. Chair. I second.
All right. So it's been moved by Representative Perez, seconded by Representative Scully to ITL 1276. Is there anyone who wishes to be heard on that before we vote? Seeing none, I would ask the clerk to call the roll on ITL on House Bill 1276.
Vice Chair Mannion,
Yes.
Rep. Alexander,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
Yes.
Rep. Smith,
Yes.
Rep. Horgan,
Yes.
Rep. Lane,
Yes.
Rep. Manos,
Yes.
Rep. Tur,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
Chairman Lynn,
Yes.
18-0.
All right. Any objection to consent? All right. And Representative Perez, can I ask you to write the report, please? All right. All right. Next, whenever you're ready, just take your time.
No, it's okay.
All right. So next, I'm going to turn to House Bill 1283, and the chair recognizes Representative Birch for a motion.
Thank you, Mr. Chair. I would, 1283, move ITL.
All right. Is there a second?
I second.
Seconded by Representative Smith. All right. All right. This is just so that everybody recall. This is the bill where the prime sponsor asked that it be ITL because he wants to do more work on it, which makes a lot of sense. All right, anyone else have any comments on HB 1283 before we call the roll? Seeing none, I would ask the clerk to please call the roll on the ITL motion on HB 1283.
Vice Chair Mannion.
Yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Page. Oh,
Lane.
sorry. Rep.
Lane,
Lane.
that's okay, yes. It's a compliment.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
Yes.
Chairman Lynn.
Yes.
18-0.
All right, 18-0. Consent, any objection? All right, we'll go on consent. And Representative Birch, can I ask you to write the report?
You may.
All right. Next, I'm going to turn to, excuse me, HB 1292. The chair recognizes Representative Alexander for a motion.
Thank you, Mr. Chair. I move interim study.
All right, is there a second?
I second.
All right. So the motion has been made and seconded on 1292 for interim study. Does anybody wish to be heard on that? All right, seeing none, I'd ask the clerk to call the roll of the interim study motion on HB 1292.
Vice Chair Mannion.
Yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
No.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Turer.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
Yes.
Chairman Lynn.
Yes.
17-1.
All right, 17-1. Any objection to consent?
I object.
All right, so it'll be on the regular calendar. All right. And Representative Alexander, do you want to write the report? Okay. And will you be writing a minority report?
I will.
All right. So the minority report. What will the minority?
OTPA.
OTPA. Okay. Well,
There is no.
There's no amendment, so I think it has to be OT.
it has to be.
That's
Oh, you can do a floor. Yeah. Yeah, he could. Yeah. I think you should just say that in your report, though, that you plan to have a floor amendment. All right. Minority. Hang on. I'm just gonna. All right. Next, I'm going to turn to House Bill 1297, and I'm going to recognize myself for a motion of ITL. Is there a second?
I second that.
It's been moved by myself, seconded by Representative Perez, and I think I probably do need to speak just very briefly to this. I mentioned it to the ranking member, but I think just for the benefit of everyone, this bill purports its purpose is to extend the prohibition on the doctrine of adverse possession, which now applies against publicly owned property, state-owned property, municipal-owned property, school district-owned property, whatever, to property that's owned by nonprofit organizations. My concern with this is that we simply don't have enough information. We heard the only person that testified was the sponsor of the bill, and I guess I think we need to have more information about the implications of this. If, for example, it's not obvious to me why the doctrine of adverse possession shouldn't apply in some circumstances against nonprofit organizations. So that, for example, this would, there seems to me there can be a lot of nonprofit organizations, some of which people on each side of the room here might have a difference of opinion on. So that, for example, on the one hand, if I own my home next to some land owned by the National Rifle Association, which is a nonprofit organization, I might say, that I shouldn't be able, because I'm a big NRA fan. On the other hand, some people here might have a completely different view. If it turns out that it's the Planned Parenthood that owns the property that I live next to, maybe they would have a different view. All I'm saying is I think we need to have more information, and that's why I'm just not comfortable voting for anything other than ITL now. If it comes back next year, they bring in some people from that really are familiar with land use law, people from various nonprofit organizations that say, yeah, this is fine or whatever. I would very likely be willing to vote something different. But for right now, this is my reason for voting ITL. Chair recognizes Representative Birch.
Thank you, Mr. Chair. I guess I hate to say with all due respect, because everybody says it, but it is with all due respect. I read the bill differently. And my understanding of the public trust doctrine, since this bill mentions nothing about nonprofits, that the public trust doctrine is a legal principle saying that the government acts as custodian of certain natural resources for the benefit of the public. It's not about nonprofits. Normally, the property in public trust are tidal waters, lakes, rivers, wetlands, and ecosystems, and it mandates that state government manage these resources responsibly, encouraging public access and sustainable use for navigation, recreation, and wildlife conservation. So we're talking potentially here, picture there's a lot of land and potentially conservation use or whatever that is mostly wilderness. And the government is preserving that land for future generations of Granite Staters to use in those natural resources for the benefit of the public. So if somebody goes and basically squats on that land where nobody's paid any attention to them year after year after year, and then somebody finds them and says, you can't live here. This is public, this is land for the benefit of the public that is held under the public trust doctrine. So you have to leave. And the person says, no, I've lived here for 20 years and therefore I own the land. And that's what adverse possession talks about. All this bill says is no, you don't. You can't be on this land for 20 years, not noticed by anybody, and then claim it's yours under adverse possession. So for that reason, I think this is a good bill and it should be OTP. Thank you.
Yes, Representative McFarland.
Thank you. I would ask Representative Birch, in the context that he just laid out, how does that address if there are boundary, I hesitate to even use the word disputes, because it's less about boundary disputes that are active and more about lack of clarity and clouds on titles and so forth that do not end up being revealed and potentially litigated until later on.
Thank you for your question. I think the best conceptual way to approach this is this bill does nothing to talk about if there's a dispute whether this is land held under a public trust doctrine or not. This bill says if it is, then nobody can say they own the land because somewhere in the middle of the wilderness, they set up a camp or something like that.
What, Mr. Chairman?
Yes.
So I take that point, and I wasn't trying to suggest that in my hypothetical that there would be adverse possession per se, but I think fences are a very common aspect of boundary definitions, and the fencing language here has me concerned that could also then call into question historical boundaries and boundary definitions.
Thank you for your question, and I'm reminded that good fences make good neighbors, as we say in this part of the country. I'm looking at the bill, and unless my copy of the bill, which has basically 3 lines, the only change in it is referring to property owned by public trust doctrine. The rest of it says already in the law that if it's segregated by fencing to identify what the land is and isn't, that doesn't change by this bill.
Representative Turner, did you have a?
Yeah, just real briefly, again, in the absence of testimony on this bill, I looked at this bill through the lens of like conservation land that's managed by either towns or nonprofits. And I think the distinction I wanted to draw is when those bodies have conservation land, they are responsible for having someone walk those lands on a regular basis and make sure that nothing is happening on those lands that isn't covered by the easement. That, my understanding, would not be true in these situations. So I do think this is important.
Right. So I guess the only thing I would say is this. First of all, the bill does not have, there's no definition of what property owned pursuant to the public trust doctrine means. And maybe it's just limited to the kinds of things that Representative Birch described, but maybe it's broader. For example, it may be that one of the requirements for somebody to get whatever, conditions you need to get to qualify as a nonprofit means that there has to be some determination that it's in the public interest in some sense. So that's part of the problem. I don't know what property owned pursuant to the public trust doctrine means in terms of limitations. And I'm concerned about that. And the other thing that I'm concerned about, and I think this is an important point. Representative Birch points out that, talks about the sort of this property that's out in the wilderness and somebody that's sort of squatting on it out in the middle of the wilderness for 20 years. Okay, that's one circumstance where adverse possession might apply, but a much more common circumstance in which adverse possession applies is there are 2 pieces of property that are next to each other, both have an owner, and there's a dispute as to exactly where the boundary line is, and one of the owners says the boundary line is on line X because I've been occupying this land up to line X for 20 years, and the other person says no. That, it seems to me, if even the most sympathetic, the Conservation Law Foundation or whatever is the owner of certain land, but a neighbor, not some squatter that just kind of showed up there, a neighbor who has lived there for a long time and has taken some steps to, and honestly believes that the boundary line is on a certain point. I'm not sure that the equities there would be the same as in the squatter example. All I'm saying is, I'm not saying that they wouldn't be, but all I'm saying is I think that this bill is not ready for prime time now. And it could be maybe corrected, in an appropriate way, and I hope that would be done next year. So that's, anyway, anybody else wish to be heard? All right, seeing none, the motion. Oh, I'm sorry, yes, Representative Smith.
Could you just tell me in the bill where we're talking about not-for-profits? I haven't seen that.
Well, it talks about property owned under the public trust doctrine, and my recollection very clearly is that the one witness who did testify specifically referenced nonprofits.
I see. Thank you.
Now in fairness, he may have been talking. He may have had in his mind, the Conservation Law Foundation or all those things. But the problem is that it doesn't say that. It doesn't say that. And I think at the very least we would have to have some kind of definition. So that's my concern. So the motion is ITL on House Bill 1297. Unless anybody has further comments, I'd ask the clerk to call the roll.
Can I ask a question?
Of course.
Would it be possible if we held this bill that we could try and perhaps talk to somebody that might have experience in this to understand? Because now I'm questioning if
There's already a motion.
oh, there's already motion. Okay, all right.
Well, let me ask you this. I think since we're in the second year, it doesn't make much difference. I would be happy to change this to interim, to withdraw my motion and make it interim study, if that's going to make a difference with anybody. But if it's not, then all right. So it seems like it's not. All right, then I'm going to stick with the motion of ITL. All right, so its motion's been made and seconded for ITL, and I would ask the clerk to call the roll.
Vice Chair Mannion?
Yes.
Rep. Alexander?
Yes.
Rep. Tripp?
Yes.
Rep. Andrews?
Yes.
Clerk votes yes. Rep. Perez?
Yes.
Rep. McFarland?
Yes.
Rep. Scully?
Yes.
Rep. Ball?
Yes.
Rep. Birch?
No.
Rep. Smith?
No.
Rep. Horrigan?
Yes.
Rep. Lane?
No.
Rep. Manos?
Yes.
Rep. Turer?
No.
Rep. Rombo?
No.
Rep. Bergeron?
No.
Chairman Lynn?
Yes.
12-6.
12-6 ITL. All right, I will write the majority report. Who will write? Will it be a?
Yeah, I'll write the minority report on OTP.
All right.
Bob.
Chairman. All right. All right. Next, I would take up House Bill 1313, and the chair recognizes Representative Scully for a motion.
I move that HB 1313 ought to pass.
I'll second that. Is there anyone wish to discuss the issue?
Yes.
Representative Birch.
Thank you.
Mr. Chair, point of order.
Yes.
I also wish to speak. Would you prefer that I speak first or you?
Oh, okay, no. That's a valid point. If there's going to be a discussion, then you should feel
thank you.
as is.
I can go after you, but I just want to let you know I was going to speak also.
That's
Perhaps
fine.
you want to hear what I have to say.
Yes, no, absolutely. No, I want to hear. You're right. You're right. You should speak first, Representative.
Thank you very much. I will say that this bill has affected me personally. As a member of the Knights of Columbus and 40 Days to Life, I have stood outside both those facilities and respectfully and peacefully prayed that God give people the grace to recognize the divine spark and to voluntarily end what I consider to be this Holocaust. Personal issues aside, I think the existence of this bill is unconstitutional. And a very similar bill had been struck down in Massachusetts. I also understand that an attempt had been made to have the bill struck down here, but it was turned away by the First Circuit Court because nobody had been charged under it, and therefore the court said nobody had standing. But I personally believe that having this law on the books has a very chilling effect on people, and I personally consider it an affront to American spirit and culture. And I heard testimony saying that people felt that if we removed this free speech zone, that it would increase the possibility of violence. I personally believe it's exactly the opposite. I think when people are allowed to speak freely, that decreases the chance of violence. When you put a tape over somebody's mouth, they will look for other means of expression. So I wish to have this gag removed from the people of New Hampshire and this stain removed from the laws of New Hampshire, and therefore, that is why I made a motion not to pass.
Right. Chair recognizes Representative Birch.
Thank you, and I certainly respect the faith of the representative. I also am a person of faith. The difference perhaps is when I go to my place of worship, I have to do it with armed guards. You don't. And I think it's worth saying that this is a safety measure. It is a way to balance, which what we do with the First Amendment and why this is constitutional. We balance several rights in the First Amendment. And we have done that with the buffer zone. What we do is create a space for people to say what they want to do in a reasonable way, obviously not violence, and allow people to access their civil right to go and get medical treatment without somebody standing a foot away from them and screaming in their faces while they are having a medical situation. It's only about safety. And as we heard in the testimony and the discussion, this bill was drafted after the Coakley decision to take into account what the Coakley decision from the Supreme Court said. The courts have upheld since Coakley many, many buffer zones. So there are also buffer zones in front of the Supreme Court. There are buffer zones here at the State House. There are buffer zones at funerals. There are buffer zones in our voting places. To pick out one particular form of buffer zone and one particular one particular group of citizens and say they shall have less protection than the protection we routinely provide to other citizens of this state by use of these kind of zones seems to me to be puzzling. Why we would want women and to some extent men who go to a health clinic to have less protection than other citizens of this state. So understanding that the First Amendment says that regulation can be done for time, place, and manner. So that, for instance, if the two groups want to protest something, they have a right to protest, but they don't have a right to protest at the same time, place, and manner. One group will just have to do it 2 hours later, if that's what the situation is. But regulations, and by the way, this buffer zone is content neutral. If people wanted to go to stand up at a health clinic and scream and yell they're in favor of women's reproductive rights, they also stand up to 25 feet away. So it's not the government favoring one side or the other. The buffer zone applies to all. And the final thing I want to say is to quote Governor Sununu, who vetoed a similar bill. Why do we need to pass it? There's been no harm done that he was aware of by having the buffer zone when he vetoed it. And I think that's worth thinking about. Thank you, Mr. Chair.
Anyone else wish to be heard? Yes, Representative.
Actually, just a quick question for you, Mr. Chairman, if you'd be so kind. I wanted to make sure my understanding is correct, that even if these statutes were repealed, the public peace laws and obstruction laws would still pertain in the same way they do elsewhere.
Yes.
Thank you.
Yes, absolutely. All right. Yes. Sorry, Representative Horgan?
Yes, very quickly. I was brought up with a Catholic, although I haven't remained active in the church to the extent that Representative Scully has. But two things I remember from when I was being brought up. One is the Catholic Church did teach us to respect other people, even those who agree with us, and also I guess maybe there's three things. Also, secondly, the Catholic Church has opinions on lots of issues other than abortion. So this is not the only. The Catholic Church is not merely an anti-abortion. Abortion is a small part of the many things that many issues that they try to educate Catholics on. And finally, we're taught that God is omnipresent, so He can hear us praying even if we're 26 feet from the entrance to a parking lot rather than 24. So you can still. This doesn't prevent anyone from praying. It just creates a physical buffer zone around certain facilities, which is probably sometimes justifiable. Thanks.
Anyone else wish to be heard? So I guess I would comment very briefly. I'm probably one of the few pro-choice Republicans. I supported the late-term abortion bill, but that's sort of the limit as far as I'm concerned. But this, I have to say, with deference to my colleague, the ranking member, I think this bill has not been enforced because it could not be enforced, because it would be unconstitutional. I think that I feel pretty confident about that. But more importantly, the thing that, if in some sense, I really do think that the opposition to this bill is sort of reminiscent of kind of the consolation prize. You lost Roe versus Wade appropriately, in my view. Even though I'm pro-choice, I think Roe versus Wade was wrongly decided. I'm delighted that it was overruled. And I can't help thinking that there's some sense that, well, this is the consolation prize. We lost Roe versus Wade, but we'll hang on to this, and this will be appropriate. I think it's not appropriate. I think it's unconstitutional. It interferes with freedom of speech. And even though as I say, I am pro-choice, I have no problem with women going to reproductive health clinics. I just think this bill is a bad idea. So that's why I'm going to vote in support of it. Yeah, Representative Smith.
The first words that come to mind, Mr. Chair, are with all due respect. And those are getting old. I understand that, even though it's real, that I hear you every time you say that you are a pro-choice Republican, even though there might be people who disagree with that assessment based on how you vote. However, this issue has nothing at all to do with Roe versus Wade. There is no reasonable way to say that this is a condolence prize. In fact, long before Roe was overturned, the issue of barriers was enforced. And the reason it was enforced is because across the country, we have examples well documented by people on both sides of the issue about violence that takes place in the area near where reproductive rights facilities function. We all know, by the way, that Planned Parenthood and other reproductive rights facilities perform a whole series of necessary health procedures, tests for men and women, and other kinds of services that improve the quality of health care for people in this state. This is a bill that is, well, the existence of the barrier is to try to make sure that we never have in this state an instance of violence, of hostility, of direct attack on people who are doing nothing other than to meet their own personal reproductive health needs. And if in fact there has never been a case, I would say that's great. That shows we have been able to find a balance to encourage people to keep their distance when they have every right to protest, but no right to interfere with an individual's desire to receive the kind of reproductive health care that she, or by the way, he, since reproductive rights facilities do provide services to men, and I hope this doesn't come as a shock to anyone, but by and large, men and women are involved in the issue of pregnancy, so this does not affect only women. I believe that this is an approach that makes sense in this state. It represents First Amendment rights. It honors those of us who would choose to go and pray to whomever we choose to pray. Doesn't interfere with that at all. It all does is say, let's just keep our distance. And I hope that whether or not one agrees with the principle of a woman being able to control her own body, one does recognize that under the First Amendment, while anyone can say what they choose to say, in the words of one of our former respected judges, no one has the right to shout fire in a crowded theater, and here no one has the right to stand in someone's face and attack what they are doing under their own protected constitutional rights. This asks no one to change their views. This asks no one to comply with behavior that they don't accept. Personally, all this says is to each his own or her own, and to let women and men go into a reproductive rights facility without fear of being attacked, verbally or physically. Thank you, Mr. Chair, and I'm sorry that I took so long.
No, anyone else wish to be heard? Representative Perez and then Representative Lane.
Pardon my ignorance of the law, but do we have any other private entities that have a law protecting them with this type of boundary? Private entities, because this is protecting, and we talked about voting and we talked about places, all that, but are there any other private entities that have this protecting them?
I'm not sure who that. I don't know the answer to that, but I mean I suspect the answer. Is no. But if somebody has actual information,
yes.
Please.
Yeah, if I could respond, I know, I'm not sure about law specific, but I know protection of synagogues, especially what's going on in New York City, that the police are keeping anti-Israel protesters a certain distance away, And that may or may not answer your question, but it's for the exact same reason, for protection of people who wish to worship.
I understand that, but I'm asking,
And that's
this is
private.
a law. I'm asking a specific law.
All right, I don't think we have an answer. Representative Lane, you wish to be heard?
Yes, thank you. And I'm probably going to get emotional. I think that if the people who want to come closer than 25 feet were only there to pray silently without screaming, we wouldn't be having this problem. I have witnessed a lot of screaming, my office used to be right across from a clinic, and it was very intimidating. I didn't even want to park near there for fear of my own safety, just getting caught up in some of the shenanigans that were going on. If people were respectful, we probably wouldn't need this law. But unfortunately, not everyone is as respectful as Representative Scully, who I don't know where you're from, so I can't refer to you that way. But it is real, it is scary, and I have witnessed it. And we do have a woman's right to choose, and having helped many people exercise that right, I can tell you this law is necessary, and to repeal it is a very dangerous precedent. Thank you.
Right. Anyone else wish to be heard? All right, seeing no one. All right, the motion is OTP on House Bill 1313, and I would ask the clerk to call the roll.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez,
Yes?
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Oregon,
No.
Rep. Lane,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rombo,
No.
Rep. Bergeron,
No.
Chairman Lynn,
Yes.
10-8.
All right, 10-8. OTP. All right.
I will be writing a minority report.
All right. Representative Scully, will you write the majority?
I have already sent it to you, Chairman.
Oh, okay. All right. All right. And Rep. Smith will write the minority. And ITL, obviously. Is that Representative Smith?
Yes.
Okay. All right, thanks. All right. Next, I'm going to turn to HB 1356, and the chair recognizes Representative Perez for a motion.
Ought to pass.
All right. Is there a second?
I second.
All right. Motion is ought to pass, moved by Representative Perez, seconded by Representative Andrus. Does anyone wish to 1356? Statute of limitations on for violation of the statute prohibiting medical
Ought to pass.
transition.
It's
Right.
extended.
Anyone wish to be heard on 1356? Seeing none, I would ask the clerk then to call the roll. The motion is ought to pass.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith,
No.
Rep. Oregon,
No.
Rep. Lane,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rombo,
No.
Rep. Bergeron,
No.
Chairman Lynn,
Yes.
10-8.
8. All right. Representative Perez will write the majority. Who will write the minority?
Mr. Chair, I will write the minority, and the minority will be no.
Okay.
I
Smith.
Mr. Chair,
Yes.
I don't expect a response. I just wonder if people might give some thought to when issues like this and the previous issue that we debated became political rather than substantive. Just wanted to raise that question. Thank you.
Interesting question. I'm all right.
And good for you for not responding.
All right. So, what's that? Oh. Okay. Yeah. No. Right. So I guess what I want to do is just to make sure I'm covering all the bases before we do that. I'm going to turn to HB 1127. This is the bill by myself and the ranking member relating to the Uniform Voidable Transactions Act. And I'm going to open and immediately close the executive session on this and postpone it until our next meeting, which will be on February 25th. And I'm going to schedule it for just for purposes of not violating the rules.
Which bill?
I'm sorry. You're right.
And
You're right. I've got the wrong date.
Mr. Chair, just rule wise, you don't have to even call the executive session. You don't have to open it. You don't have to close it. You just don't have to call it as chair. You don't have to take any action.
All right. So, all right.
Just
fine.
so you can save
Okay.
yourself from
All right.
having to
Good.
reschedule.
Well then, all right. So we're not going to take up 1127 today, and we're not going to take up 1384 today. We will take them up at a future time. And you're right. I'm sorry about the 20. We're not.
We're not meeting on the 18th.
Right. We're meeting on the 20th. We're meeting on the 20th. Yes.
And the 25th.
Right. So yes. No. Yeah. We're meeting on the 20th, the 25th, and the 27th. So right. All right. Okay. So now, Representative Kuta, back to where. Moving right along. Yeah. All right. So I'm going to turn now to CACR 29, and the chair recognizes Representative Kutab for a motion.
I move ought to pass.
Is there a second?
Second.
All right. So the motion has been made by Representative Kutab, seconded by Representative McFarland. Representative Kutab, you wish to speak to your motion?
I will very briefly. We all got a copy of the voter's guide for this and the voter's question for this. This one sentence was very clearly not in the voter's guide. It was very clearly not in the question to voters. It was added after voters voted for it. And for that reason, I strongly feel that it wasn't adopted in a proper manner.
Anyone else wish to be heard? Yes, Representative Birch.
What's in front of us is not the question about whether some constitutional amendment in the past was passed appropriately or not. That can be decided by the courts. What we have here is a constitutional amendment to abolish the right of the Supreme Court to make the routine and other rules governing the administration of the courts and the practice and procedures to be followed in all such courts. So let's not confuse the issue of what we're voting on here. We're either going to allow the courts to do their administrative work or we're not. We have a Supreme Court Advisory Commission on Rules that our chair is a member of and has been for many years. I was privileged to be on it a brief amount of time. And that widely hears from the public, from attorneys, from judges about administrative rules, among other things. Simply put, the court has to have authority to adopt procedural administrative rules with the force of law, because that is part of the judicial power itself. And it's part of the separation of powers, which is in our Constitution and the like. A court that cannot control how cases are filed, managed, heard, and decided is not an independent body. It is dependent then on politics and political bodies. From the founding of our country, American constitutional design has assumed judicial control of court procedure. You can go back to Hamilton's arguments in Federalist number 78 that say courts must be independent to check legislative overreach and also check the Federal Rules Enabling Act model in which rules are done. So to make it brief, this constitutional amendment would create chaos in the day-to-day administration of the court system. Thank you.
Anyone else wish to comment? Representative Horgan.
Yes, this constitutional amendment was passed in 1968.
78.
78? Okay.
78.
But it's been there for almost 48 years, and there's been other attempts to overturn it. In terms of what the voter guide said, it might, if somebody wanted to do the research, it might be fun to go find the minutes of that constitutional convention. I think it was the constitutional convention rather than the legislature. That was during the period when we still had constitutional conventions and the legislature anyway. So somebody might want to go back and look at the legislative history, but I think it was pretty clearly aimed at clarifying that the court system has the power to punish people who break its rules or don't follow its procedures. That's my personal belief. That was the purpose of it, and not everybody feels that way. But I'm going to vote against it and I think as a practical matter, it's only going to take about 135 members of the House to block this. So they only need 134 aside from me to kill this. So that's why I'm voting ITL. So,
all right, other people wish to hear. So, yes, Representative McFarland.
Thank you. I would just want to say that this is not a separation of powers issue. This is a separation of powers fix, and it's precisely for that reason. I know that the member does not wish to acknowledge that separation of powers is not the same as separation of bodies, but I think it's a misrepresentation to say that this CACR would create a further concern.
All right.
Mr. Chair, I would appreciate words not being put in my mouth. Thank you.
Let's just stick to the people will say what they're going to say. So I'd like to be heard briefly on this. So first of all, I will not in any way attempt to justify the fact that the ballot question, it was not just the voter's guide. For a while I thought that was a kid, but it was not just the voter's guide. The actual question that people voted on did not contain the last sentence of the amendment saying the rules adopted shall have the force and effect of law. In my view, that was inexcusable. I can't understand, but apparently I should say, it's my understanding that the way constitutional amendments were presented back then, and apparently as recently as 1978, is that they did not always contain the exact wording on the ballot that they do now, and that was, I think, really was a very bad thing that it didn't. But I'm going to be voting against this amendment for this reason. I think it's really important that you understand suppose that you took out the last sentence. What would the constitutional amendment mean? The court has the authority to adopt rules of practice and procedure. It seems to me it's very obvious that whether that last sentence was in there or not, those rules would have been enforceable. I mean, stop and think about it. You mean to tell me that we went through all the process of adopting a constitutional amendment to give the courts the authority to what? Make suggestions? We're adopting this rule. You can comply with it if you want to, but you don't have to if you don't want. Of course not. Whether that last sentence was in there or not, the rules that are adopted by the court are enforceable. And that's all that it means, have the force and effect of law. It simply means that the court can enforce them. It can provide remedies and penalties if you don't comply. And the important point I think to make is long before that amendment was adopted, the court rules were enforceable. If you go back and look at our case law from way before this amendment, the court would take action against litigants dismissing a case or imposing some kind of remedy for people who didn't comply with the rules, because of course they have to have the authority to enforce their rules. The main point of the 1978 amendment was to consolidate the rulemaking in the Supreme Court. Before that time, each level of court made their own rules. And in fact, as I understand it, I wasn't there at the time, but as I understand it, there was quite a turf battle between the Superior Court and the Supreme Court for a long time about who was going to make what rules and who was going to do what. This amendment says it's the rulemaking function is for all the courts, ultimately rests with the Supreme Court. The other point that I would make is, and this is where I think to some extent I disagree a little bit with Representative Birch. There has always been a question about what is the extent of the rulemaking authority that the courts have for practice and procedure. There was a time in the late 1990s when the court seemed to be going down the road of saying if something can be characterized as practice and procedure or court administration, the court has the exclusive authority to make rules and the legislature can't interfere. I wrote a long law review article, or a bar review article, pointing that out and proposing a constitutional amendment to change that. It went before the voters twice. The first time it got in the low 60s, and the second time less, but it didn't pass. But fortunately, between the time that article was written and some later time, I had the privilege of becoming a member of the Supreme Court. And during my time on the Supreme Court, we decided two cases, one authored by then Chief Justice Delanus and the other by me, which specifically overruled those earlier cases, saying that if something could be characterized as practice and procedure, it was the court's exclusive jurisdiction, and basically said, I took the much more sensible position that says the legislature, if the court makes a rule and the legislature doesn't like it, the legislature can pass a law to overrule what the court has done, with a very minor exception, and that is if something pertains, to the inherent judicial function, so that if the rule in effect it would interfere with the court's ability to operate as a court. So just to use a sort of an obvious example, if the legislature were to make a rule saying in a criminal case the only person that can be heard is the prosecution, not the defense, obviously that would interfere with the court's ability to function. But other procedural rules, and there are, if you look at our statutes, there are really, literally, probably hundreds of statutes that are perfectly valid that affect court procedure, and those are all constitutional. So I think that the balance between court rulemaking and the legislature's ability to control that appropriately is in the proper balance right now. And although I don't, for a minute, justify putting questions on the ballot that don't have the exact language, I really think, candidly, it's harmless here, because the constitutional amendment would have meant exactly the same thing whether that last sentence was in there or not. So for that reason, I will be voting no on the OTP motion. Representative Birch.
Just briefly to say that I, for one, appreciate the court's historical knowledge not the court, our chair's historical knowledge of this issue, especially the turf issue between the Supreme Court and the superior courts. And there is some benefit of having discussion of some of these because we learn. Thank you very much, Mr. Chair, for your presentation.
Chairman Lynn,
Yes, Representative Scully.
if I may weigh in briefly.
Sure, of course.
I think you make a very persuasive argument, and I do understand why you would want the court to be able to make its own rules. So I'm not even going to argue that, but this is more just of a general philosophical or even legal issue, which is if two parties enter into a contract, I don't believe after both parties have signed, one of the parties gets to alter the contract after the fact. I think that would be struck down as something that was basically illegal. So in effect, when you put forward a constitutional amendment, I would liken it to the legislature proposing a contract with the people of New Hampshire. And so they saw the wording of the contract, the people of New Hampshire signed on and said yes. And I'm not sure who altered it after the fact, but somebody did. And from my perspective, that would make that contract void. You could put another contract before the people with that language, and probably, or they may even all sign on to it, because again, I think you make very valid arguments, but you don't get to alter a contract after the fact. That voids the contract, and I think this issue, I will be voting for that issue.
All right. Anyone else wish to be heard? Yes, Representative McFarland.
Thank you, Mr. Chairman. And I think in light of your comments, I just wanted to add, and I was attempting to save us some time earlier and be succinct, but I apologize to Representative Birch if my succinctness did not properly convey what I was trying to convey, and so I think I want to do that. As much as I take all of the things that you said, Chairman, as valid with regard to the rules, I don't think any of us who would support this resolution are suggesting that the courts would not have the same ability that they do today to promulgate and enforce the rules. I think that the question at hand is whether or not the legislative should have the ability to create law, to create statute, which, if it touches on procedural aspects and is not unconstitutional, would control. Do I think that the legislative body would typically and should be implementing statutes that would ride roughshod over all of the court's procedures and rules? Of course not. But I think at the end of the day, what we're saying here is that it should not be constitutional for the judiciary to enact legislative artifacts, to enact laws.
All right. Anyone else wish to be heard? All right, so I think we're ready for a vote on the motion of OTP on CACR 29. I'd ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
No.
Rep. Smith. Rep. Horrigan.
No.
Rep. Lane.
No.
Rep. Manos.
No.
Rep. Turer.
No.
Rep. Rombo.
No.
Rep. Bergeron.
No.
Chairman Lynn.
No.
9-9.
9-9. So it'll be without recommendation. All right. All right. Who will write? Representative Katab, you write the majority report?
Well, there's no majority.
I'm sorry. You write the report in favoring OTP.
Yes.
All right. And I will write the minority report or the ITL report.
That's fine.
Mr. Chair, maybe it's
Yeah.
better if you let somebody else write that report. Just because I wouldn't want you to speak. I mean, it's not a majority of the committee, but it's up to you. But
yeah, no, I think I'm going to do it because I think the background would be important for people. All right. All right. So next, I'm gonna take up HB 1001, and I'm gonna recognize myself, and I'm gonna move, even though that's my bill, I'm gonna move ITL. All right. So I'll recognize Representative Mannion. I'm sorry. I recognize Representative Mannion,
Thank you, Mr. Chair. I move ITL.
and I will second. All right. Is there any further discussion on the bill? All right. Seeing none, the motion on 1001 is ITL, and I'd ask the clerk to please call the roll.
Vice Chair Mannion,
Yes.
Rep. Alexander,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith. Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
Yes.
Chairman Lynn.
Yes.
18-0.
18-0. All right. Thanks, Dennis. I appreciate that. All right. Any objection to consent? No. All right. Consent. Thanks, Dennis. I appreciate that. All right. All right. Next, I'm going to turn to HB 1032, and the chair recognizes Representative Alexander for a motion.
I move ITL.
All right, Representative Andrews,
I
second.
second the motion.
All right, it's moved by Representative Alexander, second by Representative Andrews to ITL. Anybody wish to be heard on 1032?
I'll go first.
Yeah,
that's okay.
Sure. No, that's fine. Go ahead.
I just think this isn't needed. We had members of the disability community here in person to present a bill about how they need quorum exceptions for being in person to meetings. However, they made the effort to come to Concord to present in person. Therefore, I don't think we need the bill. Thank you.
Representative Perez, I think I saw your hand up.
I was basically going to say the same thing, except that I have very mixed emotions about this, but I do feel that it is not necessary as well.
Anyone else wish to be heard?
Yes,
Yes, Representative Ward.
Well, I'm the prime sponsor. This is a very important bill to the disabilities community, and even though the citizen who came in to present it is not at least have a visible disability. She did send me an email yesterday reminding us she did have a picture of her son, who's a very vibrant and intelligent person, but would not be able to come to a meeting of a public body in person if he was a member of one. So I think this is just a very simple and respectful thing to do for members of the disability committee. And it's and I am passing around an amendment which just adds the last sentences. Nothing in this subparagraph shall be construed to require public bodies to offer remote attendance for their members. And this committee is in fact one of those public bodies. We have to theoretically, well, I mean, the House of Representatives is one of those public bodies, and our rules, we do have the technology available to have remote meetings with committees, but we've chosen not to. And so I would urge you. I will be like my alternative motion will be ought to pass with the amendment that I'm passing around. I think it's I just think it's a very simple and respectful thing to do. Some people, so there are people who want to serve who can either very rarely come in person or never come in person. So no matter how much, it's not a question of them not wanting to make the effort. It's a question of the fact that it is possible for some people to come into these meetings, but they're still capable of participating. And certainly, I mean, I agree. Usually, being in person for meeting is better, but participating remotely is better than not participating at all. And there's also there are some boards and other public bodies which have specialized in disabilities related issues where they have difficulty even assembling a quorum because of the, so. I
All
would,
right, Representative Smith.
Thank you very much, Mr. Chair. Of course, I know that Representative Hargan knows that the legislature does not choose to be part of 91A. So we're not talking about what happens in the legislature. We're talking about what happens in other entities. This is, I think, a modest proposal that addresses the needs of members of our community who deserve the right to participate to the best of their ability. I say this because at the moment I'm part of that community and I know how difficult it is. And at some point or other, all of you are going to be part of that community, either temporarily or permanently. All this does is make it possible for individuals who care to participate in the highly honored, democratic, small d, process of being involved with organizations, making public decisions, to participate even though at some particular point they might not be able to be there in person, and their absence in no way means their lack of commitment, just as their presence, perhaps at great difficulty in a hearing, does not mean that since 1 or 2 or 10 could come, that means everybody could come. Perhaps I'm particularly aware of the problems that come from mobility and other related issues, but I think that it is a denial of the rights of individuals who should be respected in our society, in our community. If we were not to accept this, but I would ask that if we were able to defeat the motion, the next motion would be OTPA, with the amendment that Representative Hargan has presented and that clarifies one possible area of confusion. Thank you, Mr. Chair.
Thank you. Other people wish to be heard? Seeing none, I guess we're ready for the vote on, the motion is ITL on HB 1032.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
No.
Rep. Smith.
No.
Rep. Horrigan.
No.
Rep. Lane.
No.
Rep. Manos.
No.
Rep. Tur.
No.
Rep. Rombo.
No.
Rep. Bergeron.
No.
Chairman Lynn.
Yes.
10-8.
All right. Representative Alexander, can I call on you? Again, if you get too many, just let me know. We'll figure it out.
I only have 2 so far, Mr. Chair.
All right. So
Too
Representative
many.
Alexander will write the majority. Who will write the minority?
I've got a minority report already prepared, so
okay.
I'll,
All right.
Representative Horgan, you can write mine. How's that sound?
Oh, okay. Maybe I can do that if I have time. So,
And would Representative Hargan's motion be OTPA?
yes,
And that would be
OTPA
OTPA. Okay.
with Amendment 0495H, which, I guess would that go on the calendar as, for the minority rather than just for me? I'm the only person whose name was up there in the masthead, but I
No,
believe,
you would be for the minority.
yes.
Yeah, for the minority. Yep. All right. OTPA. OTPA for the minority report. All right. All right. So let's turn then to HB 1115, adding a definition of citizen of New Hampshire, and the chair recognizes Representative McFarland for a motion.
Which one, Mr. Chairman?
1115.
Oh, okay. In that case, I would like to move amendment, I believe it's 0190H. Let me just check on that.
First, you have to make a,
Oh, I'll move ought to pass with that amendment.
All right.
I'll second it.
All right. So, yeah, so. So it's move R11.
It's the one about Gold Star.
yeah, I know.
This was handed out during the hearing. I remember it.
Yeah. All right. So, all right. So there's the issue before the floor is whether to adopt Amendment 2026-0190H. Anyone wish to be heard on the amendment?
I'll just say a couple of words. I think we touched on this at the hearing with the introductory testimony, but this amendment is simply with regard to RSA 110-B:81 to amend that as requested by the Adjutant General's office and reflects current practice.
All right. Representative Lane, yes. Oh, okay. So did you? Do you have another copy?
Here.
Is it a short amendment? She has a copy right now.
Oh, yeah. She's looking at a copy now. Okay.
I just don't like to vote on anything.
Yeah. No. No.
So is this a replace all amendment, or is it adding to what's?
No,
in
it
the
is.
book?
It is simply inserting that paragraph in that one statute in order to reflect the desired interpretation with regard to potential recipients of the New Hampshire Medal of Honor, and not have any confusion arise or change of interpretation arise there.
Thank you.
All right. All right. So, anyone else have anything to say on the amendment? All right. Everybody comfortable doing this by a show of hands? All right. So on amendment 2026-0190H, all those in favor of adopting the amendment, please raise your hand. Keep them up. Hang on. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. 17, okay. All right. 17 to 1. All right. Okay. All right. All right. So the amendment is adopted, and now, again, I recognize Representative McFarland. Do you have, on the main issue, do you have a motion OTPA?
I do move OTPA, Mr. Chairman, and I don't feel we need to debate it much further. I already covered that in the hearing, so I'll save my voice.
All right. Is there a second to the motion OTPA?
I will second.
All right. Seconded by Representative Alexander. So the motion now is OTPA on House Bill 1115, moved by McFarland, seconded by Alexander, and we're ready for to call the roll.
Vice Chair Mannion?
Yes.
Rep. Alexander?
Yes.
Rep. Tripp?
Yes.
Rep. Andrews?
Yes.
Clerk votes yes. Rep. Perez?
Rep. Perez?
Yes.
Rep. McFarland?
Yes.
Rep. Scully?
Yes.
Rep. Ball?
Yes.
Rep. Birch?
No.
Rep. Smith?
No.
Rep. Horrigan?
No.
Rep. Lane?
No.
Rep. Manos?
No.
Rep. Turer?
No.
Rep. Rombo?
No.
Rep. Bergeron?
No.
Chairman Lynn?
Yes.
10 to 8.
And 8. OTPA. All right. Representative McFarland, you have the honors. And who will write the minority?
I'll do it. Yes.
I'm sorry.
Oh, me, Representative Oregon.
okay, thank you.
I do not have this one prepared yet, so.
That's okay. Already. It would be ITL, is that correct? All right. Oregon. ITL. All right. All right. All right, next I'm going to turn to HB 1116, and the chair recognizes Representative Tripp for a motion.
I move ITL.
Is there a second?
I second the motion.
All right, motion's been made by Representative Tripp, seconded by Representative Andrus. Anyone else wish to be heard on HB 1116?
Right. That's fine.
Seeing none, I would ask the clerk then to please call the roll.
ITL.
I'm sorry, it's on ITL, yes.
Vice Chair Mannion?
Yes.
Rep. Alexander?
Yes.
Rep. Tripp?
Yes.
Rep. Andrews?
Yes.
Clerk votes yes. Rep. Perez?
Yes.
Rep. McFarland?
Yes.
Rep. Scully?
Yes.
Rep. Ball?
Yes.
Rep. Birch?
Yes.
Rep. Smith? Rep. Horrigan?
Yes.
Rep. Lane?
Yes.
Rep. Manos? Yes. Rep. Turer?
Yes.
Rep. Rombo?
Yes.
Rep. Bergeron?
Yes.
Chairman Lynn?
Yes.
18-0.
18-0. All right, any objection to consent? We'll be on consent. And Representative Tripp, can I ask you to write the report?
Certainly.
All right, great. Okay. All right. Next.
Mr. Chair, could I ask a question?
Of course, yes.
Thank you very much. While you're figuring out the next bill, you have moved along at a very good pace.
Yeah.
I know your initial intention was to just go straight through. There are a number of us who feel the need to discuss in some detail how we might act on certain bills we haven't acted on yet. And I wonder if you could reconsider your decision not to have a lunch break so that we could, in fact, have a lunch break and of a reasonable amount of time, which means more than 20 minutes to post the talk and then come back and continue at this very good pace.
You know, let me just ask you. Let me ask you this. Let me ask you this question. As you know, there's one bill that I'm recused on, and the other issue that I at 1 o'clock I have to leave to go test. So I'm wondering if we could. Do you think that there are other things that your group needs to talk about besides the one that I'm recused on?
I'm not in a position to speak for other people. I know for myself exactly what I was interested in making sure I understand what's at stake.
Well, let me ask you just generally to the group: would everybody be comfortable in continuing until we get, for lack of a better term, to try to get as far as we can get before 1 o'clock, and then recessing for lunch and so that your group may have. Does that make sense to everybody?
That would be a great accommodation. Thank you very much.
My only observation, Mr. Chairman, would be that I have to introduce a bill at, I believe it's 2:30, so I'm hoping that we can be done with it.
Representative Alexander will be exercising his right to keep and bear brass knuckles if we don't, if we're not out of here by 2:30. So.
Oh, really?
Yeah, I was just gonna say.
I don't think. All right.
Subject.
Yes, Representative Perez.
So you're gonna leave at 1, they're going to caucus at 1, but we need to get that bill spoken on while you're not here. So my only concern is, are we going to allow people to eat their lunch at the table and then only caucus for a half an hour so we can get that bill done before you come back?
They're gonna caucus at lunch, they're saying.
Yeah. Yeah.
but are we gonna do
But
a
people
whole?
are gonna roll in at 1:30, 1:45,
Right.
so it's gonna,
So-
we're gonna say it's a
See how-
hard
let's
1:30.
see
So,
how quickly
yeah.
It's a hard
we do
1:30.
these four, and
Right,
then
let's
decide
try to
if
get
we-
through these four, and maybe maybe we'll be able to recess at 12:30, and then,
Right.
that'll, all right. So let's see, what are we,
Bladder issues
where do we leave off?
16:31.
16:31.
Does my
Uh,
bladder get to?
All right, so next I'm gonna, turn to HB 1631, relative to the contents of the Attorney General's annual report. And the chair recognizes, Representative, Scully for a motion.
Thank you, Mr. Chair. I move on to pass.
All right, I'm gonna second that. Is there any discussion?
May I make a very brief discussion?
Of course, yes.
Well, some people would say civil asset forfeiture is a powerful tool. Others would say it's a dangerous weapon. Something that was said during testimony really resonated with me, which is we cannot oversee what we cannot see. So I think this is a really wise bill to collect the additional information to help us better understand and oversee the use of this tool and hopefully prevent the misuse.
All right, anyone else wish to be heard? Representative Tur.
I don't know if it's appropriate at this moment, but I have an amendment to offer on this bill.
Well, you can, I think, here's what I would say. I think to the extent that you would sort of object without the amendment, you may tell us why you would object, and if to the extent that relates to the amendment, I think that's perfectly appropriate thing to talk about.
Mr. Chair, you
So
have to
true.
entertain an amendment if it's not to pass motion.
Right, but I mean, before we vote on the ought to pass itself, is that what you're saying?
No, because that's the final motion, so
Right.
we would
Okay,
have to entertain
okay,
Representative
okay.
Turner's
Yeah,
motion.
Thank you.
All right, no, that's fine. So, Representative Scully, did you anything further you wanted to say?
No, Mr. Chair.
All right, then I recognize Representative Tur for a
Yeah.
motion.
Thank you, and I do want to lift up what Representative Scully said. The civil forfeiture process, I think, is worth additional scrutiny and information. It is a process that presents some inherent, I'll call it perverse incentives that could exist. So I think it's worth our while to know more about the civil forfeiture process and how much it is being used and in what situations. So to introduce my amendment, of course my phone turned off. So amendment number 0713H.
Representative Turner, I'll second your motion
Sorry, let
on
me
the amendment.
make that motion.
And I'll second it.
Thank
All
you
right,
very
moved by Tur, seconded by Alexander.
The amendment does two things. It addresses, it modifies a little bit existing law and also the bill itself. I don't need to go through everything, but speaking off the original version of the bill, it basically modifies the requirement such that the forfeiture is only reported in the fiscal year in which the forfeiture is actually completed, as opposed to all activity in which reporting would include forfeitures that are still in process and which could be reported over multiple years. So I think that part makes the resulting information that you could glean much more useful. So that was the first change, because you can look at the amounts and the activity cleanly without having to cross-reference years. The second change that I made modifies the list of items that are detailed in the original bill, and I'll real quickly go through them. Some of them are related to that change that I just made. So it removes Part E, the estimated value of the forfeiture, because it includes the value ultimately forfeited, so I don't feel like there's a value knowing the original value estimate. H and J were the two pieces that the criminal and forfeiture case numbers that were discussed in the hearing as either being redundant and irrelevant or being too revelatory of the person who's involved in the forfeiture and potentially exposing them. It removes K, which is any information about counterclaims that were filed. And again, that's because it's part of the process, not the outcome. And the last one, I think it's L from what I can see on my phone. The estimated value of the property returned or destroyed, etc. So those are ones that are eliminated. It makes a change to Part I, which simply adds if available for cases where the actual proceeding may still be going on, the criminal case may still be going on. But otherwise, it would be reported if if it's available that there's a final disposition of the criminal charge. And last, I added one provision, which is the date that the forfeiture proceeding was completed, so that we know sort of how far through the year. The last thing, well, they didn't actually add the last part that I asked for, so I won't mention that one.
All right. So, Representative Alexander.
Thank you, Mr. Chair. I think this is a completely reasonable amendment. I think it addresses a lot of the concerns raised by law enforcement during the public hearing and pares it down a little bit. And for that reason, I'll support it in the OTPA.
All right. And, yes, Representative Birch.
As much as I think the amendment is far better than the original bill, which is good, I think anybody with a basic knowledge of Google can take the name of the agency, the date of the seizure, the date of the criminal case being ended, the zip code, and the criminal offense itself, and have exactly no problem whatsoever identifying exactly who is the subject of this proceeding. So I don't think, I think the issues that were raised at the hearing persist.
All right. Anyone else wish to be heard? All right, so we're on the amendment. So does anyone object to having a show of hands on the amendment? All right, so all those in favor of adopting Amendment 0713H, please raise your hand. Sixteen, and those opposed, please raise your hand. All right, 16 to 2. 16 to 2. All right. Amen. Okay. All right. All right, so we're now on to the main motion of OTPA. Anyone else wish to be heard? All right. So it's just
It was Representative Turner that motioned OTPA.
Well,
Oh,
she gave the amendment, so.
yeah, no, so it should be, I think, well, let's. So do you, Representative Scully, are you comfortable with making the OTPA motion?
Yes, Mr. Chair, I move OTPA.
All right, and I will second that, so. Or you can, sorry, seconded by Tur, okay, that's fine. All right, so the motion now before us is OTPA moved by Representative Scully and seconded by Representative Tur. Anyone else wish to be heard? All right, then I ask the clerk please to call the roll.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith,
Yes.
Rep. Horrigan,
No.
Rep. Lane,
Yes.
Rep. Manos,
No.
Rep. Tur,
Yes.
Rep. Rombo,
No.
Rep. Bergeron,
No. Not worth the $47,000.
Rep. Lynn,
Yes.
13 to 5.
13-5. All right. Representative Scully, will you write the majority report?
Yes, Mr. Chair, I had written one. I will review it in light of the amendment and make any appropriate changes.
And who will write the minority? Will there be a minority?
I'll write the
All right. Minority Birch.
And that would be ITO.
That'll be ITL, okay.
13 to 5.
13.5.
I'll just write it was 37,000. It's gonna be very short.
All right.
Good picture.
All right. Next, I'm going to turn to HB 1634, establishing state court remedies for violations of state and federal law by federal employees, and the chair recognizes Representative Birch.
Thank you, Mr. Chair. I move ITL.
Is there a second?
I'll second that, Mr. Chair.
All right, moved by Representative Birch, seconded by Representative Alexander. Is there anyone else who wishes to be heard on the ITL motion on 1634? Seeing none, I'd ask the clerk to please call the roll.
Vice Chair Mannion.
Yes.
Rep. Alexander.
Yes.
Rep. Tripp.
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yep.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
Yes.
Rep. Smith.
Yes.
Rep. Horrigan.
Yes.
Rep. Lane.
Yes.
Rep. Manos.
Yes.
Rep. Tur.
Yes.
Rep. Rombo.
Yes.
Rep. Bergeron.
C.
Rep.
No.
Chairman Lynn.
Yes.
18 to 0.
18 to 0. Any objection to consent? All right, and Representative Birch, will you write the report?
Yes, I will.
All right. Next,
Mr. Chairman, before you go to the next bill, I wonder if it would be proper to ask to reconsider whether 1292 can go on consent.
1292.
Just remove your objection.
I will withdraw my objection.
So you're going to withdraw your objection on
92.
1292, so it can go on consent. Okay, sure.
Thank you.
Will not be writing a report.
Correct.
Right, okay. On consent. All right, consent. Okay. All right. And so wait a minute, what are we up to now? Yeah, okay. All right. So next, I'm going to turn to House Bill 1665. And hang on. And the chair recognizes Representative Kutab, who I believe has an amendment.
Thank you, Mr. Chair. I have amendment 696H. And I do have another copy of it if anybody doesn't have a copy. Yeah, I think everybody. Okay. Can you just pass that down to us, Bill?
1665.
Anything good in there?
Right. One second. No, it's 1665. Oh, the amendment number. I'm sorry.
Is 696H.
Yeah, 6968. All right. All right. So, I'm sorry, you moved your amendment. I'll second it.
Sure.
Yeah, no. Representative Kudat, would you like to speak to your motion?
Sorry. I didn't bring a binder because it's so much with all this stuff. All right, so essentially, it used to say all parties to every proceeding under this chapter and any other administrative hearing, and now it just says all parties to an administrative hearing. So it's taking out that to every proceeding under this law and any other. And it's also adding in, it used to just say RSA 516.2 to RSA 516.4. I added in 5, which is the part where the person who's requesting the subpoena pays for it, has to pay for the witness.
All right, anybody else wish to be heard on the amendment? All right, then, on, what's the amendment number again? 696H. All right, so on amendment 0696H, anybody object to doing this by a show of hands? See? Just voting by hand. Right. All right, so all those then in favor of adopting amendment 2026-0696H, 2026-0696H. Please, if you support that amendment, please raise your hand.
Is that everybody? Oh, cool.
Halfway up.
All right, so that's 18-0 on the amendment. All right, now we're on to the main bill, and I will recognize myself to move OTPA. Is there a second?
I second.
All right, moved by.
No.
Oh, no, I don't think so. No. All right, moved by me, seconded by Representative Kutab. Anybody else wish to be heard on the main bill? Representative Rumble? Pardon?
I was just going to briefly say, like, I still have concerns. I appreciate the amendment, but I still have concerns about the weaponization risks here, and in terms of any parties being able to use the subpoena power. And I was particularly concerned about the testimony we heard from the Office of Professional Licensure, how this would potentially really gum up the works in terms of our administrative hearing process, and the risks to be able to to effectively move through those hearings. So for that reason, I will not be supporting it.
All right, anyone else? Yes, Representative Birch.
Thank you. This Freedom to Subpoena Act, I think, will cause a lot of problems by turning administrative hearings more into civil warfare, and granting such an unlimited ability for parties to subpoena doesn't seem to recognize how today there's supervision over the subpoena power, which is a big power to drag in people, drag in documents, drag in potentially confidential stuff. I'm generally reluctant of big government, which is what this is. We call them parties, but it's a governmental proceeding that's pulling in citizens and documents. So I'm opposed to it.
All right. Anyone else wish to be heard? All right. Seeing none, I think we're ready to call the roll. The motion is OTPA on House Bill 1665.
Vice Chair Mannion,
Yes.
Rep. Alexander.
Yes.
Rep. Tripp,
Yes.
Rep. Andrews.
Yes.
Clerk votes yes. Rep. Perez.
Yes.
Rep. McFarland.
Yes.
Rep. Scully.
Yes.
Rep. Ball.
Yes.
Rep. Birch.
No.
Rep. Smith. Rep. Horrigan.
No.
Rep. Lane.
No.
Rep. Manos.
No.
Rep. Turer.
No.
Rep. Rombo.
No.
Rep. Bergeron.
No.
Chairman Lynn.
Yes.
10-8.
All right. I can write the majority report on this. Who wants to write the minority?
I will.
All right. Minority. It will be ITL, is that correct? All right. ITL. All right. and I'm going to turn next to 1684, which is the one that, as I understand it, if I recall correctly, the prime sponsor asked to remove. But I'll Chair recognize Representative Ball for a motion.
I move ITL.
Is there a second?
I'll second that.
All right, moved by Representative Ball, seconded by Representative Alexander. The motion is ITL. Anybody wish to be heard? Seeing none, I've asked the clerk to call the roll on the ITL motion on 1684.
Vice Chair Mannion?
Yes.
Rep. Alexander?
Yes.
Rep. Tripp?
Yes.
Rep. Andrews?
Yes.
Rep. Kutab? Oh, sorry. Clerk votes yes. I'm tired. Clerk votes yes. Rep. Perez?
Yes.
Rep. McFarland?
Yes.
Rep. Scully?
Yes.
Rep. Ball?
Yes.
Rep. Birch?
Yes.
Rep. Smith?
Yes.
Rep. Horgan?
Yes.
Rep. Lane?
Yes.
Rep. Manos? Yes. Rep. Turer?
Yes.
Rep. Rombo?
Yes.
Rep. Bergeron?
Yes.
Chairman Lynn?
Yes.
18-0.
18-0 ITL. Any objection to consent? Seeing none, we'll go on consent. All right. What's left? All right.
What?
Is that, are those the only two?
That is CACR 23.
No, let's do that. So, what transaction?
CACR 23 hasn't been.
No, has not been done yet. All right. So look, here's what I'm going to do. In light of the request, I'm going to recess the committee now until 1 p.m. and ask to return then. I understand you will have, there's two matters left, as I understand it. One on which I'm recused and one other. So you'll take up, I'm going to insist to the greatest extent I can in the other committee where I'm testifying that they would go quickly. Hopefully that'll work. But anyway, I will get back as soon as I can. I can't be here on the vote on the one I'm recused from anyway, so you'll take that up then. And hopefully I will be back in time for CR 23. But if I'm not, I sort of leave it to you whether to, I guess, depending whether to vote or not. Yes.
Mr. Chair, I just want to, I want to ask for you to explain why you're, as a legislator, recusing yourself from a vote on a legislative matter. I understand you were a judge, but you are no longer a judge, nor will you be a judge in the future. So I'd just like some more clarification on why you choose to leave the room for the vote.
Sure. No, that's a fair point. So I guess this is something that I have to say I really sort of agonize over, because I recognize that certainly if this were a judicial matter, there'd be no question I would recuse myself. If I didn't, I think I would be in trouble as a judge. The standard, I think, is different for a legislator, but nonetheless, I think there at some point there is, even though there may not be a requirement to recuse, and I'm satisfied that under the ethics rules there is not a requirement to recuse. That is not the limit of the world of recusal. There are times when a legislator can recuse even though not required to. And here, particularly since this is talking about whether there should be the opening of an impeachment inquiry where the legislature and particularly this committee would act as sort of a grand jury, I think that I have some, it greatly concerns me because candidly, I think I have two issues here. First of all, on a very subjective basis, I know the people, or at least I know all of the people that are the subject of potential investigation. Some I know very well. One I worked with, for example, for a couple of years. The other I know very well just because we worked together, even though he was not on the court at the time. So I have a real question as to whether objectively, I'm sorry, subjectively, I could be fair and impartial in carrying out my duties. And secondly, and probably more importantly, I think there is a public perception issue for this legislature in particular, but for the court, for this legislature, I suppose to some extent for me, a public perception issue. I don't think it would be in the interest of the legislature particularly for anybody to be saying, oh, you know, they canned that investigation, that impeachment investigation, because Lynn was there. He's chairman of the committee. He tried to strong arm people into, into not doing anything because he's out to protect the court. I think that would not be in the interest of the legislature, and so for all those reasons, I determined to recuse myself.
And Mr. Chair, I would like to say that I respect how difficult that decision must have been for you and how I agree with your conclusion, and I thank you for caring about the reputation of both the court and the legislature.
Well, thank you, Mr. Chairman. Yes, Representative.
I would just like to say, and thank you for those comments. I would just like to say for the record that I'm sure I am joined by the fellow members of the caucus here to say that none of us feel in the slightest strong-armed, and thank you.
Well, thank you. We are in recess until 1 p.m., where you will return with the vice chairman in running. We have two left to do.
Okay. We're gonna open the executive session on HR 38, and I'm gonna recognize Representative Alexander for a motion.
Thank you, Mr. Chair. I move ITL.
Is there a second?
Second.
By Representative Birch. You wanna speak to your motion?
No.
Any discussion on this at all? Anybody wanna speak? Yep. HR 38. Representative Andrus, you want to speak?
Thank you, Mr. Speaker. Yeah, I would like somebody or everybody make me understand why we don't want to address this. This was brought before us, and I would say the information was true. Otherwise, I don't think they would have brought it. I know nothing about the case. I'll be point blank. But I look at life this way. If the justices are innocent, we should have an inquiry, go through it, they prove their innocence, and then we're all along a happy way. Thanks.
Okay. Well, I believe the Attorney General already looked at criminal charges and found nothing. So if that's that, does anyone else want to address Representative Kutab?
So regarding the comment that the Attorney General already addressed this, the Attorney General had also already addressed Brock in a report, and the House still went and looked into Brock. So just because an Attorney General has looked to say that there's not something criminal doesn't mean that there's not potentially maladministration. And I think we were brought a lot of things before us to consider, and we've had a lot of bills regarding the court and a lack of public trust in the court, and we've killed off those bills and said we have other ways to handle this. Well, this is the way that we have to handle it, to look into it. And now we're going to say, oh, well, we were presented stuff, but we don't want to look into it. We're just going to say that these things are okay. I mean, I think $50,000 is a lot of money. I think opening up another position when you're in a hiring freeze, creating a brand new position that didn't already exist when you're in a hiring freeze is certainly not something
that sounds on the up and up to me. When your whole HR department leaves, so that you need to have a contract with the Department of Administrative Services to have any HR, I think that's another huge red flag. When you have big conflicting stories, and one of the biggest ones is that Marconi says that in a sworn affidavit that McDonald told her it was okay to see Governor Sununu. He says that he didn't say that. That very thing she was indicted for, and even before being indicted, 6 months before, she was removed from the bench by him for that. But yet if he told her it was okay, why would he remove her from the bench for that? There's a lot here, and this isn't saying we are going to impeach, it's saying that we're going to investigate it, and I don't know.
Representative McFarland.
Thank you, Mr. Chairman. I just want to respond in light of Representative Andrus's question. Speaking just for myself and from my point of view on the motion before us, I took it with extreme seriousness what was presented in the hearing, and I have spent the vast majority of my free time since then reviewing the artifacts that were presented. And yet, when I have gone beyond what was presented sounded pretty significant and pretty concerning. But when you actually start to dig into it, there is a different appearance. So, for example, we heard in the testimony from Representative Potenza that in her own affidavit, Justice Hans Marconi, and I quote, explained to Chief Justice McDonald that she was considering requesting a meeting with the governor, and that the Chief Justice's response to her was, I think you can do that, you're a constituent and you have concerns. And then she goes on to present what is supposedly a contradictory statement and says these two accounts cannot both be true. But if you actually look at the contradictory statement, it isn't in fact contradictory. There is testimony from Chief Justice McDonald where he says that he wasn't explicitly aware that the conversation had happened. He said that the conversation was news to him. And I don't see that as in any way at odds with him being aware that Hans Marconi might have intended to have a conversation. That's not the same thing as knowing that the conversation has been scheduled and has happened, or indeed what the topic of it was. And if you go through the rest of the evidence that's presented, again, it's presented in a way that sounds problematic. But then, for example, with this business of the monies being paid out to Diane Martin, monies which, mind you, she was perfectly owed in her contract, we have a statement that was published by the courts of New Hampshire by not just Justice McDonald, but by Justices McDonald, Donovan, Cantway, and Gould, acting together, publishing a statement together, where they said that every personnel decision regarding Miss Martin was made collectively by the Supreme Court. So the notion that in fact Chief Justice McDonald might have acted wrongly on that, if we believe that, if we think we have evidence to that extent, or even probable cause to that extent, then what we're in fact saying is not that Gordon MacDonald acted wrongly, we're saying that 4 or 5 justices acted wrongly, right? And I think that we need a little bit more than what we've seen before us so far to conclude that in fact 4 of our Supreme Court justices were colluding to do something wrong when they simply paid out the benefits that were owed to one of our long-standing employees. So as much as I went into this thinking that it was a matter that required some deep consideration, and as much as it may still be true that there are facts not yet in evidence that demonstrate impropriety or maladministration or whatever, I don't think we have seen that smoking gun. I don't think we have even seen evidence that there is a smoking gun. And I'll be supporting Joe in his motion.
Anyone else wish to be heard? Representative Perez?
Thank you. They stick together. I was in medicine for 42 years. You can never get one doctor to testify against another doctor. Smoking gun, there's a lot of evidence here that could possibly or probably be actual facts that were presented to us, and the whole purpose in this is to investigate it, to see somebody, if you say one thing and I say the other, one of us is lying. One of us are telling a mistruth. One of us are not being forthcoming on what happened. There's more than just the thing with the HR, the woman in the HR. There's lots of stuff going along that needs to be. What about the whole divorce thing? What about not doing what was ordered for the divorce to come forward with? There's a lot of stuff here, and unless we investigate it, we will never know. And I'm telling you, our constituents are furious about this. There have been so many bills brought forward about justices and them having to be held accountable because all of this was so public, and they are furious about it. And if we turn around and say, poo, 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 we're getting rid of all of those, how does that make us look? Especially for us Republicans, I'm going to say, because it's a Republican judge that we're one of them that we're looking at. They're going to say, oh, that's just because he's a Republican. Anyway, I think we need to do what our constituents want. We had multiple bills coming forward trying to reel in justices and make them accountable. We need to pass them.
Anyone else wish to be heard? Representative Kutab.
I just want to respond briefly on that. The practices and procedures, according to the AG report, was that she was entitled to that if she was leaving, but she in fact did not leave. In fact, another position was created for her to go into, and she started that position a couple of days later. So if she was leaving the branch, then yes, she would have been entitled to it, but she wasn't entitled to it because she wasn't leaving. So I think that's the big thing that makes that piece wrong.
Anyone else? Seeing none, I'll ask the clerk to call the roll. The motion is ITL on House Resolution 38.
Vice Chair Mannion,
Yes.
Rep. Alexander,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
No.
Clerk votes no. Rep. Perez,
No.
Rep. McFarland,
Yes.
Rep. Scully,
No.
Rep. Ball,
No.
Rep. Birch,
Yes.
Rep. Smith, Rep. Horrigan,
Yes.
Rep. Lane,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Why should that matter? Why should that matter? It hasn't been finalized yet.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
12-5.
And the motion passes. At this point, I'm going to close the executive session.
Well, there will be a minority report.
Oh,
on that.
I'm sorry. Yes, you will write a majority report.
Sure.
And who will write that minority report?
I would defer to Joe, but otherwise I'll do it.
Joe's going to do. That's a majority.
my
I'm asking about if there will be a minority report and who
Oh.
will write it.
I'll solicit your feedback on the report. How's that sound?
That works.
I'll write the minority report.
Okay. Representative Kutab will write the minority report, and this will go on the regular calendar. Okay, and with that, I'm going to close the executive session on House Resolution 38. All right, at this point, I'm going to open up the executive session on CACR 23, and I recognize Representative Birch for a motion.
Thank you, Mr. Chair. I move ITL.
Is there a second? Representative Smith seconds. Do you want to be heard on your motion?
No.
Anyone else want to be heard on CACR 23? Representative Kutab?
I will be voting no on this because all year we've heard that we have other ways of addressing things, other ways into looking into things, but then the very bill that we could have actually looked into this, we just voted no. So right now, we in my eyes, we have no oversight. So I think we need this in order to have oversight. Thank you.
Anyone else wish to be heard? Seeing none, I'll ask the clerk to call the roll. The motion is ITL on CACR 23.
Vice Chair Mannion,
Yes.
Rep. Alexander,
Nope.
Rep. Tripp,
Yes.
Rep. Andrews.
No.
Clerk votes no. Rep. Perez,
No.
Rep. McFarland,
No.
Rep. Scully,
No.
Rep. Ball,
No.
Rep. Birch,
Yes.
Rep. Smith,
Yes.
Rep. Horrigan,
Yes.
Rep. Lane,
Yes.
Rep. Manos,
Yes.
Rep. Turer,
Yes.
Rep. Rombo,
Yes.
Rep. Bergeron,
Yes.
10-7.
With that, the motion passes. Representative Birch, will you write the majority report? And will there be a minority report?
Christine, do you want to do the minority report on that one?
Representative Perez will write the minority report. And I assume that'll be ought to pass.
Yes.
Okay, thank you. Okay, I'm going to close the executive session on CACR 23, and I believe that concludes our business. So, unless there's something else, I will adjourn the judiciary.
Hurry up, everybody leave before Bob gets back. He'll wonder what's going on.
Right.
You need a novel tonight. Do something. You need a romance novel or something tonight to fill your palate. You too.
Whole section of law now where litigants or lawyers can sanction if they citation. Like I said, I tried to